And what brilliant interviews we've had throughout Women's Month, and it's only fitting that we ended on that note with another phenomenal woman. And with me here is Nandi Mokoena, who is an attorney and an independent competition law commentator here at the 13th Annual Competition Law Economics and Policy Conference, celebrating the 20th anniversary of the Competition Commission in South Africa. Nandi, thanks so much for coming through to speak to us.
Thanks for having me.
So it's really been an interesting conference right up to this point. You and I were talking beforehand about some of the debates that have been going on here. But just looking at what we are looking at right now in terms of the Competition Commission and the acts that govern it, 25 years into democracy, we're still struggling, aren't we? Especially with regard to creating an inclusive economy. So do you believe that the Competition Commission is doing enough, though, with what it has at its disposal?
There isn't a short yes or no answer to that question for me. I certainly think that the Competition Commission has done a lot. And if you just look around at who's at the conference and how far the Competition Commission has come 20 years into its existence, I think that the Competition Commission has made some serious inroads. There are so many case highlights to talk about, it's difficult to focus on only one. I think the Commission kind of came into prominence in South Africa's mind when it's investigated the bread cartel. That was kind of the first time people were standing up and taking notice, and that was a groundbreaking case for the Competition Commission. It signaled the beginning of kind of a change in focus, because in the early years there was merger enforcement, merger regulation that became a priority for the Commission, and then cartel enforcement, cartel regulation from that time around the bread case became a focus for the Commission, and they've done so many cartel cases since that time. So I think that is one area where I think the Commission is doing, can't say enough, but is doing a lot. I think the introduction of the corporate leniency policy in about 2004 was a great achievement for the Competition Commission, because it in part led to the breakdown of many of these cartels that we're seeing now. I think another area in which the Commission has done really well is just in the inclusion and consideration of public interest criteria in merger regulation. And you know, sometimes people don't appreciate that that wasn't always an easy thing to do, because in South Africa we have, we started out with traditional competition law, but traditional competition law principles from the EU and the US don't necessarily include public interest considerations, which are the effect on employment, the effect of a merger on employment, the effect of a merger on the ability of an industry to be competitive internationally, and various factors that you need to take into account. But the Commission has done it. You know, they've taken those cases on, and they've put public interest considerations out there, which is why we're having the conversations we're having now. They have put employment as an important issue to be taken into account during merger regulation. So that's another area where I think the Commission has done a lot.
And where do you think they ought to do more, just in terms of the shortcomings, because perhaps you haven't reflected enough on that?
So shortcomings, I think, come up as a result of the work that you are doing. In some ways, I think the Commission has become a victim of its own success, because as it succeeds, the community and the public expect it to do more. Sometimes the Commission has found itself wondering what more, because we are regulators of competition, but now people are expecting us to regulate even further areas. But even with that said, I think that there is more to be done, and I believe this is the reason why the Competition Commission has chosen this tagline of regulating for inclusive growth, because it's no longer just about applying traditional competition law concepts, not within our context, in the South African context. Now the issue has become about regulating with a purpose, you know, applying those concepts with a purpose. And in South Africa, we all know the context that we operate in. There is inequality, there is poverty, there is unemployment. And so those are critical issues that need to be tackled. And the Commission is one of those organizations that has stood up and said, well, we're not going to sit back and call ourselves plain competition regulators. We're going to get in there and we're going to regulate for inclusive growth. We're going to take competition law to its maximum. We're gonna use competition law to try and bring these reforms about that we want to see, that everybody wants to see in the economy.
Well, that unfortunately is where we're going to have to leave it. And coming to you from the Pretoria's CBD, and we are here for the 20th anniversary of the Competition Commission of South Africa. As you heard there, yes, there's still some work to be done, but some good work has been done over these past 20 years. I can tell you the Chief Justice is here, looking forward to hear what he's had to say. Already some very interesting developments coming and flowing through from the discussions and the debates that have been had up until this point. But we're going to cross back to Leanne now. For me, it is goodbye, and over to you, Leanne.